Hello, everyone. My name is Joseph May. I'm one of the attorneys at Coast to Coast Legal Aid of South Florida. I work in the senior law unit, and we're here today on the Small Claims Court Clinic, which is hosted by Coast to Coast. I am joined by the Honorable Jackie Powell, County Court Judge, Civil Division of the 17th Judicial Circuit in and for Broward County, Florida. Also with me today is Beatrice Forbes, Deputy Clerk with the Broward County Clerk's Office, again, 17th Judicial Circuit. And also with us is Assistant Law Librarian Melissa Keller with the Lamar Warren Law Library of Broward County, which is located in the main courthouse here in Fort Lauderdale. I'd like to start the clinic with you, Judge Powell. Please tell us a little bit about yourself and give us your opening remarks and your presentation.
Judge, you're on mute, just so you know.
Of course, this is what I say all day long in my Zoom hearings. All right, good afternoon, everyone. I'm Judge Jackie Powell. As you heard, I am a county court judge, a county court judge serving in the civil division. And I've been on the bench now for 6 years and about getting ready to start my second term of 6 years. And most of my time here on the bench has been in the civil division. Before being on the bench, I don't think I ever had to appear, or maybe once or twice in small claims court when someone asked me to help them out with something. And so I know it is one of those areas that we don't learn about in law school, really. And we just always kind of forge forward like any other case, but the small claims cases just are a little bit different. So I'm glad that Legal Aid has decided to put this on, this CLE on today, because hopefully it will help bring some light to some of the small variations, the differences in the small claims area. You wanted me to just go right ahead, right, Mr. May? Is that what you said? Okay. All right. So, like I said, this is an area where oftentimes, I have attorneys walk in the courtroom and they want to just forge forward just like any regular county civil case. And I have to stop them and remind them that small claims is a little bit different. So the first thing is that nobody ever knows that there are actually Florida small claims rules. So let me put that out there, that it does exist. Florida Small Claims Rule 7, and if you put that in, then you'll get the whole chapter. Also, our Chief Assistant, Chief Administrative Judge Robert Lee, over the years, had been putting together this Florida Small Claims Rules Annotated. I think the last one that he did was in 2022, and that was because the appeals, all the appeals now, whether small claims or county civil or whatever, instead of going to a circuit appellate bench, right, it now goes to the 4th DCA, and so he stopped updating them. But it is available. I Googled it today to see if it was there, and it was there, and it is a good thing to have on your desk because there would be a good guideline for how you proceed on small claims matters. The idea is that small claims are summary proceedings. So, oftentimes I have attorneys come in and they think that they're going to file a motion for continuance and that it's going to be delayed for 6 months and then the case is not going to get resolved. But the truth of the matter is a resolution can come of the case right there at the first hearing. So let me back up a little bit. We start the small claims proceedings, just like how a complaint is filed. In small claims, they call it a statement of claim, but it's pretty much the same thing. That's filed with the clerk of court, and then they issue the summons. When the summons is issued, it's going to give you the pre-trial conference date. That's an automatic thing. You will get a pre-trial conference date. And all the pretrial conferences are standard if you're at the North Satellite Courthouse, South Satellite Courthouse, or West Satellite Courthouse, or the Central Courthouse where I'm at. So it's a standard time that's set, and the clerk will tell you more about how they do that. But it is set at the Central Courthouse. All the pretrial conferences are held on the 10th floor. All the judges just go up there. It's not a regular courtroom, but for uniformity, they keep all the pretrial conferences on the room 1010, I believe. And that's where the pretrial conferences are held. So the complaint is filed, the summons is issued, and here let me say about the summons, because every once in a while something slips through. The pretrial conferences are in person only. For small claims, pretrial conferences are in person only. On that day, the judge will have probably up to 100 cases. We are not turning on our Zoom courtroom. So, and don't call at 8 o'clock in the morning and say, can I appear by Zoom? Because then it becomes difficult and it hampers with the regular proceedings. So it is in person. The summons that the clerk issues says it's in person and gives you the courtroom. So what happens a few times that has slipped through, and no system is perfect, is that attorneys will prepare their own summons and then put that the pretrial conference is by Zoom, and then when you look at the bottom, it says in person, where the clerk actually puts the information in. So however you do it, it's the clerk's information that's correct. And that is that the pretrial conferences are in person on the 10th floor if you're at the Central Courthouse. Otherwise, at the satellite courthouses, it's in the individual judges' courtrooms. At the pretrial conference, we will have mediators that are available. And so all the cases, if they hadn't been resolved before court begins, will have an opportunity right then and there to go to mediation. When you go to mediation, if you come back and the case is resolved, then a settlement agreement will be signed right there in court. The case will be dismissed right there in court, and the case will be over for the parties to conform with the settlement agreement. If there is no agreement, now on small claims cases, because they are summary proceedings, if the judge looks at the pleadings and determines that there is no case, then the court can dismiss the case, or the court can issue a judgment right then and there. For me, most often, because most of the cases are filed by self-represented litigants, the statement of claim that the clerk gives them, and it always says that you can add another page for more information. They never do that. So there is always the one sentence. There's always the one sentence, or maybe two sentences if it's a good day, on the statement of claim that says, he owes me $5,000, I want it back. And nothing else is attached, and I don't know. And if we don't have time and they didn't come with their evidence, then I will set a hearing for a final judgment hearing later on. So one of the most important things that I want to remind everyone is that these cases are resolved very quickly. In fact, the rule, the Florida Small Claims Rules, says that if you come to the pretrial conference and there is no resolution, or maybe there are two attorneys on the case and they file a waiver of appearance at the pretrial conference, if that happens, then the court shall set the final hearing within 60 days of the pretrial conference, right? And so it usually happens pretty quickly, and it does say shall. 7.00090, Rule 7.090, subsection D, that says trial date. It says the court shall set the cause for trial not more than 60 days from the date of the pretrial conference. All right. And so usually before you walk out of that pretrial conference, the judge is going to give you a date that's going to be followed by a trial order. The other thing is that because a lot of us don't practice in small claims court, sometimes I get attorneys saying motion for a default because they didn't file an answer. Well, in small claims matters, defensive pleadings are not required. Okay, now they can, or if for some reason the judge determines that something else needs, some response is needed, then the judge can order, can issue an order telling the party, the defendant to file a response, but it is not required. And so just by showing up at the pretrial conference and going to the mediation, that just invokes the rights of the defendants at that time. And so defaults are not going to be entered because a written answer has not been filed, because it's not required. And then I said that there's the summary dispositions. It's a summary disposition matter. So at the pretrial conference, or maybe at any other hearing, if there's a case management that ends up being set or something, if there is no triable issue, then the court shall summarily enter an appropriate order or judgment. And so the reminder is that these are summary proceedings. Because these are summary proceedings, also the Florida Small Claim Rules prescribes that if the plaintiff does not show up for the pretrial conference, then the judge can dismiss the case for your failure to appear at that time, right? And the same if a defendant does not appear, then a default can be entered, and then the judge will order that the final judgment package be submitted for submission, and then that will be the end of the case. Motions to invoke the rules of civil procedure can happen, and it is allowed in the small claims case, but the rule says that it must be in writing, and it is at the discretion of the judge. When you don't appear at the pretrial conference and then just walk up and say, Judge, I'm moving to invoke the rules of civil procedure. I know for me, that's not going to be sufficient because the rule says it must be in writing, and you've got to show me why on a small claims matter where we're moving to invoke the rules of civil procedure. Of course, if it is granted, then you will now come under the general county civil rules. If not, then we were going to continue as a small claims matter. Also note that sometimes we can invoke, the discovery rules or something and not invoke all the other rules. So if it's something that is specific to your case, it is important that you let us know what it is for consideration, right? So if the plaintiff doesn't appear, the case can be dismissed. If the defendant does not appear, then default can be entered, and then subsequently a default final judgment. The final judgment, when it's entered a lot in the small claims cases, the clerk of courts will prepare those. Sometimes, depending on what's going on in the courtroom, I'll just go ahead and prepare it. But the final judgment will come pretty quickly once a final judgment is entered on the record. Let's see. The final judgments, and then there is collection, and the clerk usually, or not usually, the clerk always gives that the collection paperwork to tell the plaintiff or whoever wins how to collect on a judgment. And so the required forms will be given, and then it will be up to the attorney or the litigant to proceed with the collections. If at any time the parties have settled the case, probably before the pretrial conference, or maybe if after the pretrial conference a trial date is set and there is a settlement agreement after that, then the plaintiff or any of the parties certainly can file that settlement agreement or if there was payment in full, you can certainly file the voluntary dismissal, so that, you know, that will take whatever hearings off of the docket. Before I talk about trials, here's the thing that I need to, I started to say, and I want to make sure that it's clear, right? The pre-trial conferences are preset dates. These dates are set with Judge Lee in charge. The dates for 2025 are already in place. So all the judges have their pre-trial dates throughout the year. Right? Recently, I had a motion to move up the pre-trial conference date. There is no such thing, all right? There are set dates that each judge has on a Tuesday morning to do their pre-trial conference. And so if for whatever reason, maybe you didn't get service and a continuance was granted, then the next pre-trial date is the preset date for that judge, whatever that date is. So we don't have separate days. We don't have individual pre-trial conferences on small claims cases. These are preset dates that come from the clerk of courts. And so parties have to keep that in mind. So the last time I had a pre-trial conference was in September, and my next pre-trial conference date is coming up next month in November. So just to give you an idea of how it's not every month, but it's a preset time, right? And so that's how that works. So, you know, if you're thinking, oh, I can't make this pre-trial conference, but I'm asked the judge to move it up. If there is no moving up, there is always moving forward, but it's always to the next already preset date. And can I stress again that pre-trial conferences are in person? Every time we have a pre-trial conference, I have attorneys calling or filing at the last minute that they want to appear by Zoom. It doesn't happen. It creates too much of a havoc just to do a one-off if we have 60 to 100 people at a pretrial conference. So per administrative order and per the rules, it is in person. And like I said, you can waive your appearance at pretrial conference, but if that happens, then the next thing the court is going to do is set your final hearing date. Let's see. I spoke about dismissals. All right. Continuances, yes, like every other case, if you require continuance, either for the pretrial conference or if a trial is set, where practicable, you need to file a motion for continuance. And the judge, you know, will consider it and rule on it as soon as possible. Jury trials. Are there jury trials available in small claims cases? The answer is yes. Jury trials may be had, but it must be upon written demand of the plaintiff at the time of the commencement of the suit or by the defendant within 10 days after they've been served or appeared at the pretrial conference. So yes, you can demand a jury trial. Plaintiff would have to demand it at the time that they file their complaint, or if it's the defendant seeking it, then it's 10 days after the service of the summons or the notice to appear at the pretrial conference. If that timeline of at the time of filing or 10 days after service is not complied with, then the jury trial is deemed waived. And so after that, there will be no jury trial. Okay. If there's a default, if the defendant does not appear at the scheduled time, the plaintiff is entitled to a default to be entered either by the judge or by the clerk. After the default is entered, the judge can receive evidence. So that's why I say sometimes I set an evidentiary hearing as to damages, because the rules say that we can set hearing or receive evidence establishing the damages in order to enter judgment. And it says that the judge may inquire into and prevent abuses of venue prior to entering a judgment. So sometimes attorneys appear, they get a default, and then they submit a default final judgment, and then I reject it and say, the record isn't clear that these damages are correct, so set a hearing. And then I always get pushback. But the rule, you know, the default is as to liability, as with everything else. As to the damages, the court can set an evidentiary hearing to make that determination to see what really is correct. And then, of course, as always, if a judgment is entered and you need to seek relief, the rule does provide, just like the county civil rules, that you can file a motion to vacate a judgment, and you've got to follow the rules, which is similar to the county civil rules, but the Florida small claim rules that govern that is Rule 7.190. And then certainly that can stay. If after judgment is entered, the parties come to some further agreement, then we can stay judgment, but the parties have to let us know. Oftentimes they don't let us know. And then the only time I know that there was an agreement after judgment was entered was when they turn around to file another motion for final judgment. And when I look at the record, I say, but final judgment was already entered. And then when they come, they'll say, Judge, but we had an agreement. So if an agreement is entered into after the final judgment, then just shoot me an order saying that we've agreed. Let's vacate that final judgment and let's dismiss pursuant to the settlement. And then, of course, you're going to put the sentence in that the court retains jurisdiction, because then that way I will have jurisdiction over the case if the settlement is not followed through. But, you know, because it's small claims, and remember, I have to remind attorneys all the time that we don't automatically get these pleadings. So if there's something that you want us, you either have to set a hearing or you have to call the JA and let us know. All right. So I think I've been talking for 20 minutes and I'm gonna yield the time because we do have the clerks and the librarian to talk.
Thank you, Your Honor. Next up, Ms. Forbes.
Good afternoon.
Good afternoon.
The clerk's office assists with the navigation of filing the small claims cases. We do not provide legal assistance. We do sell the forms that are needed to start the filing of a small claims case for 15 cents a page. That would be the civil cover sheet, the statement of claim, and the summons. We take in the filing fees depending on the amount of the filing of what they're suing for, what they're seeking depends on the filing fees that are needed to file the small claims case. It could range anywhere from $55 to $310. It also depends on the number of defendants that they're trying to sue. Usually our general statement of claims are for money damages, security deposits, or auto negligence. Supplemental filings are also taken in at the front counter after we've set up the case. If they need to file any pro se person that needs to file supplemental filings after the case has been initiated, we also do that at the front counter. We provide that service. They also have the option of filing it electronically through the Florida e-filing portal. So they do have those two options, or they can mail it into our office. We also accept it through the mail if they need to file any further pleadings on their case. Once the case is originated in our office, it's automatically, the system provides a case number and provides the pretrial date. We put that on the summons. The summons is provided back to the person. They do have several options on how to have the summons issued or served on the parties. We have the option, we do provide, they can provide a money order for $40 to Broward Sheriff's Office, and we do have a drop-off box here that BSO, Broward Sheriff's Office, does pick up twice a day. If they choose to use that, we're more than happy to take the summons and the money order and provide that in the box for BSO to pick up. They could take it back with them and take it to BSO themselves. Or the third option is they are provided the information that they can hire a private process server, and they can have the summons served in that way. Once the case is filed and we receive all the paperwork, they get a true copy of everything they filed with us. They get the court date, and they are provided any information that they need if they wish to file supplemental filings, whether it be, any attachments or anything that they want to provide for the court before the pretrial hearing. That's how our small claims process works when they come in person or to the front counter.
Ms. Forbes, is that it?
Yes, for small claims, yes, that's
Very good. Thank you.
And may I just interject just a moment? I failed to say it, and I'm sure that we know, but just so that we're all clear, is that small claims matters are matters up to $8,000. So anything over that, it goes to regular county civil, but small claims is up to $8,000. That's the jurisdictional limit.
Ms. Forbes, I had one quick question. Are there any forms available online on the clerk's website?
Yes, we do provide the small claims packet. It may be purchased online.
Thank you so much. Thank you for all this information. I did also want to introduce that we have a special guest with us this afternoon, Madam Clerk, Brenda D. Foreman herself. Thank you for joining us and for your office sharing all this important information with our community.
You are so welcome. It's an honor for me to be here and to hear both sides, judicial as well as my staff, because I'm very confident in my staff and when they are given presentations to make sure that the community knows exactly what we do when it comes to certain areas. And thank you so much again.
Madam Clerk, this is Joe, and just to reiterate, I want to compliment you on the quality of your website, and we will, at the end of this, post up the link for that for both practitioners and for the pro se litigants who come before you. It is a wealth of information and extraordinarily well done.
Well, thank you so much. If there's anything more that we can do to make it a lot better, give us some feedback and let us see what we can do.
We will.
Thank you.
Next up, Ms. Keller.
Hi, guys. So I'm Melissa Keller. I work at the Law Library. We're located in the old side of the courthouse in the north building on the first floor. So I guess for small claims, I'm kind of or for any of these cases, I'm kind of the in-between between mostly what the pro ses are trying to do and getting it to the clerk properly and getting their summons issued and all that. We do provide the small claims forms as well. They can come into the library and purchase them in person. I think a small claims packet will run about $2 in the library total. And it comes with everything, the pretrial summons, the statement of claim, and the civil cover sheet just from the clerk, or they can request it via email from the library. We do require that all email requests are sent, like they have to send it to me and ask me for what they want. But if I have it, I will reply. We don't give legal advice, but I do have the luck of having practiced in small claims for many years, both working for a firm and doing coverage counsel. So I have a nice view, a visual of what going to a pretrial conference and being there and working through that system actually is. So I'm able to help them a lot procedurally with, just getting it filed and understanding what the pretrial conference means and talking to them about the mediation and that'll happen there and any stipulations and things like that. They can also request, they get down the line and they've made an agreement, they can request things from us like the affidavit of non-compliance or affidavit of non-payment, same thing, to seek their judgment if the stipulation hasn't been followed through on. We also do have the judges for version of the small claims rules. That's available in the library. I usually try to direct them, say, Google like Florida Rules of Civil Procedure, because that'll bring up the Florida Bar website, which kind of gives them a nice link to all of the most current rules. We do talk to them often, pro ses, of course, especially about things like filing motions and discovery and things like that in small claims. Of course, we can't give them advice on what they should or shouldn't do, but we can guide them to the rules and talk to them a little bit about how the process works and moving through the system and showing up and getting their service through the clerk. With the email service, they can request whatever forms they need. They can come into the library and do research if they want. We have Westlaw, LexisNexis, and Florida Law Weekly available for free for the public to use in the library only, though. So anything like that, they can come in and do here. For the email service, it's just forms. I usually do tell them they can email me questions. I always say, I'm not afraid to say no, or I don't know if it's a question that I'm not allowed to answer, or I just don't know. But I do allow them to ask me because I man the email system, so I don't have to worry about other people getting in there and saying something or doing something maybe they shouldn't. What else? Sometimes I help them navigate the clerk's site when it comes to figuring out like where they're supposed to be or what they're supposed to do. So I wholeheartedly agree about the quality of the Broward clerk's website, and it being probably the easiest to navigate in the state. So that helps a lot. Mostly I try to talk them through the system, make sure they're in the right for their amounts. It's 8,000 or less, and they don't need to be in county court. If they're suing maybe like an insurance company or something like that, and it's in the small claims arena, but money-wise, but not because of who their defendant is. What else? We don't really help them filling out the forms. We're not supposed to help them like fill them out for them, but they can come in, and a lot of it is just talking to them about what they're trying to do and making sure they have everything they need. And kind of just pushing them through the system majorly procedurally rather than, they know they want to sue their friend for whatever amount it is. So it's a lot of just kind of navigating them through the court system itself and getting them to the clerk's office with their copies and all of that stuff and, ready to go. And that they know who the plaintiff is and who the defendant is, and they filled in the forms completely and they've done their notary, or if it's something the clerk can sign, they go up there and get the stamp instead of signing it here, and those kind of things. Otherwise, for any other kind of cases, not small claims, we provide the forms as well, so they can seek those if their amounts go up, or if they need to amend, we can provide forms. It's usually standard forms, and we teach them to just kind of add amended and to do it again and all that, direct them regarding the money orders and stuff like that. So when they get to the clerk, maybe they're a little more situated. Sometimes I try and call the clerk if I can. It's quite a distance between myself and the county clerk over in the West building. So I try to call there and kind of figure out what's going on, or call some of the other clerk's offices, the West Satellite or the South or whatever. And it's helpful just because I know what I'm asking, so I can get them some answers maybe a little more quickly and without the time of the clerk being expended, because the county clerk's office is always busy. So, but that's about it. We're here to help. We're here to support the attorneys too, or the pro ses that come in, and anything they need, I always try to navigate them somewhere.
Well, I've got you. For those who are not IT proficient and might need to go back and deal with some of the more old school publications, things like Florida Jurisprudence Second and things like that, and the reporters, and they want to do some additional reading, all of that's available. They could be directed to that, and they would be able to go back and see if it was a breach of contract claim and they wanted to have an understanding of, what it takes to submit a claim or to the elements of a claim and what they need to do to oppose it, things of that sort, places where they would go and start looking for the information to do something like that. Yeah.
Yeah, absolutely. And we also, a lot, of course, we have all our reference materials and the stacks and everything. But with our Westlaw subscription, we do have all the Thompson materials that come along with that. For Lexis, we don't, but for Westlaw, we do. So any of those Florida jurisprudence or American jurisprudence, all those that are put out by Thompson, they can see the most recent version on Westlaw and email themselves portions of that or print if they want. We do have printing in the library at 25 cents a page. So they can do that, or, they can always, use the books and all that. Yeah. And then when it comes to the collections portion, they usually will come in with the form from the clerk. I try to guide them to number 1 on the clerk's page, which is about the re-recording, and make sure that they get that done. We do have some collection resources, just like an email that we put together that gives them some basic links. So usually I'll tell people, email me and ask me for collection resources, and I'll send them a page with links, probably with Legal Aid's phone number in there too, both of them. And that form from the clerk, the 2-pager that kind of gives them a guide on things for collections. Sometimes I think the biggest misconception, especially in small claims when they get their judgment, is they think they're going to get their money and that the judge is going to enforce the judgment for them. And they get a little stumble there when they realize it's a second process. So we try to kind of at least get them moving on that, even though some of the things can be a little complicated, like a garnishment or what have you. But the re-record is the fastest thing they can do. And it should always be number 1. So we try to get them started there.
And the flip side of that is for the debtor who's going to be the subject of the enforcement of any judgment, there are certain exemptions that are available,
Yes.
up to and including homestead, having household, and so on. Are there materials available for those folks as well?
Yes, we do. Well, so for the homestead exemption, no, I don't have a form for that. I do have a claim of exemption, of course, and I do kind of try to guide them through that, just having done many of them before in practice. So I'll get them the form. Usually I try to ask them about the notices that they should have received, things like that, because a lot of times these people, unfortunately, they're just not they're not. I don't know if they're not getting them, but they're not realizing what they're getting in their mail, and they're not quite understanding that, these things are coming in, like, notices from garnishments, and that they need to act immediately. So I try to talk to them a little bit about that, guide them towards the statutes, and provide them with the claim of exemption, and kind of get them to, you need to get this filed. Generally, judges set them for hearing rather quickly because of the nature of the business. But to follow up and make sure they get a hearing, little tips like, if you're leaving a claim of exemption and your exemption has been granted, you should ask for an order at the time of the hearing. And, most plaintiffs' attorneys, I know I would draft those immediately, those people's banks or their wages are being garnished or their bank accounts are being held. And sometimes that can be a sticky situation for them. It's not their money. It's not all their money. It's not, whatever. So just with getting those orders so that they can go to whatever entity and get their garnishment released, and kind of talk them through a little bit of how that's an evidentiary hearing and how that will go and things like that.
Very good. Excellent. All right. What I'd like to do at this point, ladies, is just kind of go back and go through the hypothetical case, and just maybe fill in some additional information as we would go from pre-suit all the way through to post-trial and judgment. And when it comes to filing, the rules of civil procedure and the Florida small claims rules and the rules of judicial administration all sort of come into play when it comes to things like that. So in terms of preparation, what are the kind of things that a potential plaintiff would want to consider in terms of which location they would file the case, what kind of paperwork they would need if it were something like a breach of contract case, the things that they would need to include with the statement of claim and the paperwork that's going to be submitted at the time of filing? Beatrice, could you take that?
Yes, so the location of where the case will be filed is per Administrative Order 2021-35-CO. So there's an administrative order with all the zip codes and locations of which courthouse location they would file, or their case would be set up as. So they can go to any location and file their case. It's just depending on their zip code where the case will be set up, and where, if they have to go to court, that's the location that it will be held at.
All right, I'm gonna give you a hypothetical so that it might add some additional information. You got a guy who wants to sell. He lives in Hollywood. He wants to sell his neighbor his old clunker of a car. They agree to a payment arrangement, and the neighbor buys the clunker car, and he's supposed to make X amount of dollars per month. And then over the next year or so, the guy who had sold the car moves up to Hillsborough Boulevard, up close to A1A. So he's living up close to the North Branch, and the guy who bought the car is still living down in Hollywood. And so at that point, if the guy who wants to file the lawsuit is up in the North Branch, would he be filing at the North Courthouse, or would he be filing at the Hollywood Courthouse? My thoughts would be that because the transaction was created there in Hollywood, and the car is located in Hollywood, and the defendant's located in Hollywood, even though the plaintiff is up in the north part of the county, the case should be filed in Hollywood. If that's not if the plaintiff does not do that, what is the defendant's recourse?
So
For
the case
transfer?
per the administrative order, the cases are filed per the plaintiff's zip code. So it would be their current address at the time of filing the case.
And if the defendant wanted to perhaps have the case moved to the Hollywood Courthouse, could they file a motion to transfer and bring all of those factors in that I talked about?
Absolutely.
And they would do that before or at the time of pretrial?
I mean, if they want to file a motion, the clerk's office will accept the filing of a motion, and it will be sent up to the judge.
Okay. In terms of things that need to happen before the pretrial, judge went through a good number of things, but one of the things that no one has talked about yet is if you are a Creole only speaker or a Spanish speaker only, and you're going to need a translator, do you have the option to file a request for an interpreter or translator to assist at the time of the pretrial or even at trial? And if so, how would that work?
So the answer to that question is no. In civil, in the civil court, translators, interpreters are not provided. So if that person if English is not their first language, then they would have to bring someone with them to interpret for them. Because we the administrative orders does not provide for translators in civil cases. So there's not an automatic thing like in criminal court where we could call and get an interpreter to come. That doesn't happen in civil. And so oftentimes what happens is if either the plaintiff or the defendant appears and they don't have a friend with them that can help them, if there's someone in the courtroom who can let them know in their native language, we will reschedule the hearing and let them know that for the next hearing, they need to bring someone with them who can help them with the interpretation.
Okay. In terms of Judge, I would probably direct this to you. If a defendant wants to file a counterclaim or maybe even a cross claim or a third party claim, should they be thinking about doing something like that before the pretrial conference, or was that something that would be addressed at the pretrial conference?
It could be, I mean, the truth of the matter is, especially for the self-represented litigants, they don't always know what they should know. And so a lot of that information does come out of appearing at the pretrial conference. Then, they'll tell me, well, I want to do this or that. And, then I'll say, then you'll have to file a counterclaim, but then I can't give them legal advice. So that's all I can tell them. So then maybe they'll have to go down to the law library and ask Ms. Keller, what is a counterclaim and how do I go about doing that? But certainly, so also with self-represented litigants and in tandem with small claims cases, the practice has been, and I think it's been accepted through the District Court of Appeals, is that the judges are required to read through what, a lot of times they write pages and pages. If there's a response, there's pages and pages of how and why or whatever. And it is the judge's responsibility to read through whatever that self-represented litigant has filed, which is why everything that they file, the clerk brings to our attention right away. As soon as they write something to the judge, they file it with the clerk. That same day, the clerk's office is bringing it to that individual judge. And then we now have a responsibility to read through it to see if we can figure out what it is that they're asking for. And then based on their writings, we can also set hearings to either to clarify, or if we figure out what it is that they're asking for, then we will set a hearing for that matter for them.
For a pro se litigant, again, Judge, this is for you. For a pro se litigant, if there is a defective service or process, is that something that you look at ahead of time, and would you even address that?
I'm trying to see where I would see that there's a defective service.
For example, it normally it requires in-person or at least 2 visits before the 3rd time that they attempt sale. And that's usually written on the face of the return. If the face of the return does not set forth that information, if it seems like there was 1 visit and it was posted during that first visit, then it's on its face defective. How would that be handled?
Then we definitely catch it. I think all my colleagues will tell you what, if service was affected by posting and is whether it's a self-represented or not, if service is affected by posting, that's one of the things we all look at. And so if it was not done correctly, yes, then, if they ask for a default, then we'll deny it to say that, the service was defective. So that definitely we are tasked with looking at, those things, the pleadings and the service of process when they come in.
Another twist on that same theme, if the defendant was to be served but had to go out of town on a family emergency and a neighbor was watching the dog while they were out of town, and the process server knocked on the door, the neighbor opened the door and delivered the summons and complaint, then that would not be effective service. But how would that be raised by a defendant if they wanted to raise it?
Well, so oftentimes, then they come back and the neighbor, because we've had that happen before. So they come back and the neighbor says, hey, somebody served this. And, and I think maybe through the law library, maybe through Google search, we get these motions to quash service all the time, that they've figured out that, and so if they file a motion to quash service or they say that they weren't there when service, then we set a hearing to make that determination.
Goes back to, and again, Judge, I'm staying with you.
That's okay.
At the time of pretrial, there's the referral for mediation. Thing that I have seen happen many times in the past and was always a concern was that folks who are new to the process and unfamiliar with what's going on around them, that they're looking at trying to reach a settlement agreement and have the whole thing done and then walk out of court and think, well, okay, that's fine. Maybe I've got a settlement or agreement and I've got a payment arrangement. But then maybe they don't make the payment in the full amount, or they don't make the payment on time. Usually it is the case in settlement agreements that if a plaintiff turns around and files an affidavit saying that there's a violation of the settlement agreement, there's no further hearing. There's simply it's brought before the court and a judgment is entered, correct?
That's correct. When there are forms that are used for the settlement agreements, in the small claims courts. And in addition to telling them how much they pay per month, there is also that language about if you default. And I know myself, and I know a lot of, if not all my other colleagues, I try to stress that over and over and over in court, that if you enter into an agreement, that you must comply with the agreement, because then, as you said, the plaintiff can file that affidavit of non-compliance and get a final judgment against you. However, they should also know that, you know, they can file if the plaintiff has to submit that affidavit of non-compliance. Once that's filed with the clerk, it is also served on the defendant. So if there's anything in that affidavit of non-compliance that's not correct, we can sua sponte set a hearing on that, because they are entitled to an automatic final judgment. But if the defendant or whoever owes is in default, files a motion, says, you know, the affidavit of compliance is not right, I did pay or whatever, then the court will go ahead and set a hearing on that. But we won't sua sponte do it, because we're not allowed to do that.
This is more of a timing issue, but in that sort of a situation, if a defendant has listed an email address at the time they file their responsive pleadings or at the pretrial, whatever, then that would be the kind of information that would be distributed to them by email, correct?
Right.
And if they did not provide an email address, then that would have to be delivered to them by mail, correct?
That's correct.
Okay. So there's a time lag there for those folks. And if you don't check your email every day, then you could sit on it for a week and have a problem.
Right. Right.
Okay. All right. Discovery motions and discovery in general. I understand that it's very limited in small claims, but if for example, in my car hypothetical from before, if the defendant came back and said, look, you know, what this guy sold me is that he turned back the odometer on it, the engine that was in that car is not the engine that was from the manufacturer, it fell apart and all of this stuff, and I told him all this stuff and he said go fish. So then I want to be able to do some discovery with the plaintiff. So in a situation like that, would you start with interrogatories? Would you start with a deposition? What would be made available at first?
I was trying to find the page. I think the rule allows for depositions. So if they do a motion for that, then the court can grant that for depositions.
And if they needed to go further based on what they learned during the deposition, then they could come back and ask the court to reconsider.
Correct.
When it gets to trial, non-jury trial and jury trial, what sort of information is provided to the parties beforehand so that they will prepare in terms of what sort of witnesses they're going to bring, what sort of documents they're going to bring? How will that work?
So in these cases, we never really know what it is, right? So the trial order and whether it's a jury trial or a non-jury trial, certainly if it's a jury trial, there is going to be a pre-trial conference before the jury trial. If it's a non-jury trial, the order is going to go out and the order is very detailed. So there is a section for witnesses. If you have witnesses, this is what you must do. If you have exhibits, this is what you must do with them. You know, we tell them that they've got to make copies for the other side. They've got to file it with the clerk. And it's got to be the original copies so that, you know, if they make the originals, so that if they make copies and it comes out dark or something when they file it with the clerk, that they have to bring the original to the clerk's office so the clerk will have it. So for the final hearing, the clerks will bring those original documents up if the judge requests it. So we can tell them as much general information as possible. You know, we are not going to go read their complaint and say, oh, maybe you should have a bill or something, not like that. But we will definitely say anything that can help you to prove your case or any person who has personal knowledge about this case that you want to bring, you should list them as a witness and you should file those exhibits to be presented at the final hearing. So the orders are pretty specific as to exhibits, witnesses, time, and the deadlines of when these things need to be filed.
I'm thinking about mission of evidence at trial and they're required to do, and how they are required to ask questions between direct and cross-examination, you know, those kind of things. Yes, no questions or open-ended questions. But in the context of pro se litigants, what I'm thinking is how much additional discretion does the court have so that those folks don't know about the rules of evidence and direct and cross-examination. So I would just like to explain how that factors into how the trial is conducted.
Well, oftentimes, well, first of all, as you rightly say, the court, the judge does have discretion with self-represented litigants in that area. And the fourth DCA has ruled on that over and over again. And so while we cannot tell you how to win your case, we can't tell you what to say to make you win your case, the court does have discretion with self-represented litigants that we know have not been to law school or taken any legal course or anything. So what the judges will do is we would ask the questions like for introducing the evidence, you know, when was it created, who created it, those kinds of questions, to see if they do have at least the foundation to submit that. And like when it's two attorneys, I will ask the deputy to show it to the other side, and oftentimes they will look to see if this is a receipt or a bill and if they have any objections. And the court, certainly we tell them what legal objections are, and 90% of the time they don't have no clue what those are. But you know, we will ask them what the objections are. And again, this is where the court does have discretion to make that interpretation as to what it is that is being said. But that does present a problem oftentimes because I say it often, and what I'm up against often is that either the self-represented litigants, they don't read the order, they don't read anything. Like, you know, I'll say you've got to file your witness list and file your exhibits, and then they show up and they tell me, you know, oh, well, I didn't do it, but I have it on my phone, and I can show you my phone, you know, and I have to explain, you know, all of this. So the big thing is that I say this, I think at every CLE conference that I go, especially when I'm talking to self-represented litigants, the big thing is that you must read. You must read when you get that summons. Read it from the top to the bottom. I see that often in evictions cases. They don't read it, but you must read it. When you get the trial order, you must read it. Read it from top to bottom so you can see what is required of you. And that will usually help you. I mean, I'll have people filing pages and pages of exhibits, but that's because they will say, I read the trial order and it says that if I have exhibits, anything. So as they find them every day, then it becomes 20 exhibits of the record, but I'd rather have that than not have anything at all. So if they read, at least they will get that basic information.
Okay, so the trial is over, jury trial, non-jury trial, whatever. The trial is over. Somebody's unhappy, and they want to have the thing reconsidered in some fashion. Motion for new trial, motion for rehearing, and appeal. They're different, right?
They are different. All right. So the motion for new trial is going to be based on, you know, maybe there is some evidence that was available, you know, wasn't available, that became available after the trial, that you can do that. And you know, you can file your motion. And again, when you file that motion, you don't just file it with the clerk. Well, if it's a self-represented litigant, we are going to know because like I said, everything that the self-represented litigants file, the clerk is tasked with bringing it to the attention of the judge. If you're an attorney and you file online, or if you're a self-represented litigant and you do the e-file and it doesn't go through the clerk at the clerk's window, then you are going to be tasked with bringing that to the attention of the judge. It is whichever party is filing that motion needs to bring it to the attention of the judge. And like I said, the judges don't get everything that's e-filed. We don't see it unless and until somebody brings it to our attention. So that's one thing. And so when the court gets it, then we will review what the motion says. You don't necessarily get a hearing unless the judge decides that it requires a hearing. There won't be a hearing. The judge will just make a ruling on that, either granting or denying, and that will be that. If it's for an appeal, just like with every other rule, you have 30 days to file your appeal, and you can do the notice of appeal. The notice of appeal can be filed locally at the clerk's office, and then they will send the information up to the appellate court. And there is also a filing fee when you do that. I know that there is room for indigency if you're indigent to excuse you from making the filing fee. One thing I see that happened recently, a lot of people know they can file an appeal. They file the appeal, but while the appellate court ruling is pending or it's pending for them to pay their filing fee, then they file motions after that, asking the lower court to look at some motion. And so they've got to know that once you file that notice of appeal, the lower court, the county court judge loses jurisdiction until the appellate court says that we can do something. So a lot of times people do that, I think sometimes in panic. They file everything, they do the notice of appeal, they file a motion for a rehearing, they do everything. But whatever gets docketed first, if that notice of appeal gets docketed first, then the judge cannot do anything until the appellate court says that we can. And I've had sometimes that the appellate court will just send back an order and say, Judge, please make submit your order or your ruling on this motion before we proceed. That has happened. But just know that, we're stuck once you file that notice of appeal.
If you filed a motion for new trial, that would not stay the 30-day period on a notice to appeal, correct?
That's correct. It does not.
So if there's no disposition on the motion for new trial, if you think that an appeal is going to be necessary, it's incumbent upon you to go ahead and get that notice of appeal filed so you do not waive the right to it.
That's correct.
Post-judgment, and if I could stick with you, Your Honor, in terms of post-judgment, discovery is available post-judgment even in small claims, correct?
That's correct. You can do requests for interrogatories in aid of execution of the judgment. That's what that is called. And so, yes, that is also the discovery is available post-judgment.
And when a plaintiff is trying to get a default or a default judgment, they could include in the language for that document a mandate that the defendant submit a fact information sheet.
That is always a part of it. Once a judgment is entered, that's part of the information that I know the clerk does provide. They will give them the information about the fact information sheet. So that's going into the collections. Once a judgment is entered, then the next thing, because that's always written in the order, that they have that 45 days to complete that fact information sheet and to return it. And then now the court does have jurisdiction over that part of it as well. So if you don't fill out the fact information sheet, then the plaintiff can come back and say, Judge, we sent it. They have to show and prove that they sent it to whoever the party who needs to pay. And then if you don't comply with that, then there can be a motion for contempt for failing to respond or something. I think over the years that I've done it, maybe once I've had somebody do a motion for contempt, and by the time we came to the hearing, and explained to the defendant that it is required, then they agree to fill it out. So as a lot of times it's just the lack of understanding and wanting to know why people want to know my personal business. They already have judgment against me, but it is allowed. Yeah.
In a situation, go back to my car hypothetical. So the plaintiff won in that case, and he wants to get his car back, and he also wants to get the difference on the amount that was owed compared to the whatever the difference there might be with the value of the car if he gets the car returned. So then they would be looking for maybe a garnishment of wages, garnishment on bank accounts, things of that sort. So post-judgment, it's incumbent upon the plaintiff to go out and file a motion and to get that granted, and then get the execution entered and then served on whoever is going to be receiving it, whether it's the bank or the person who possesses the car, correct?
That's correct. And that's
Right.
why Ms. Keller mentioned that, you know, that she gives a full packet, because the judgment, getting that final judgment alone is not going to be enough for you to get your money. You know, yesterday I had one of those hearings, final judgment in favor of the self-represented plaintiff. And he says, Judge, are you going to put in the order how many days they have to pay me? And I say, no, I'm just going to say you're entitled to judgment. And now there is collection. And now that I know that Ms. Keller has packages, I always send them to the clerk, because I know that the clerk has forms and can show them the website also. But now that I'm aware that Ms. Keller is fully and actively engaged, I will also include Ms. Keller to say, maybe you need to go to the law library and find out, tell them, I have a judgment, what do I need to do next? So.
Yeah. The only
Yep.
difficult part with the garnishments is that it's very hard for them to follow all the procedures in order. So I try to guide them to the statute. We do have garnishment forms, like a motion for continuing writ or a motion for writ, but it's hard for, like, I can't say here's all the forms that you need for a garnishment and make sure you do that, these notices and da-da. So I will usually, when they say they want to do a garnishment, I will provide them with a motion. I try to be very clear that this is not the only form. The statutes for garnishments are laid out. They're very tedious and long, but they're laid out beautifully. And they really do give you the timeline for when things to have to be done. So I try to stress to them, number one, that they can do it if they read, like Judge Powell says, they have to read it. I try to guide them, you know, insert names, insert words so that you can make it understand, like plaintiff Bob talks to, and say it out loud, because it makes it easier for them to grasp it. But that they need to be very, very hyper focused on the rules of the statutes for the garnishments, and they need to request from me what they need. So they, you know, I can get them started. I can, you know, usually I'll give them the motion and the writ, like the beginning and the end, but I try to be very clear with them that this is like kind of a journey. There's required notices. They're very time sensitive, and they have to make sure that they're doing all of that. But if they can get to the point where they're savvy enough to come and ask me and to come down here, we do have the forms. We have the appeal forms. We're very aware of the Florida Bar Appellate Handbook for pro ses, so we guide them to that. We have the garnishment forms, all that stuff. So sometimes it's just a matter of getting them down here and getting them past the point of the thought process that their money was coming. And then we can kind of guide them to get them started. But they've got to be ready to dig in and for that kind of stuff. You know, they usually will come down and say, I need a writ of execution. And I'll say, well, what are you executing on? And they'll say, well, I don't know. The clerk said, bring the writ and I'm going to get my, you know, and I say, okay, well, you're kind of at the beginning. And that's where we'll start with that 2-pager from the clerk that gets them started, gets them reading. And fact information sheet's another one. A lot of times the language will be in the judgment. A lot of times it won't be. So when it's not there, I kind of try, okay, well, you know, you can issue it, but if the language is not in your judgment, then what's your recourse if you don't get it back? So I'll say, you know, maybe you should try to move the court and ask for, you know, to be able to do post-judgment collection, you know, for the fact information sheet, to issue it so that way, when if you don't get it back, you can move forward with something like a compel. We have a lot of very basic forms for them. So usually it's going to be a blank motion. And I try to talk to them about, which is the bones, and that's it. And I try to talk to them about the body being, you know, what you want and why you want it, or what you want and why you think you should have it, so that we can kind of get them moving in speaking to the court in some kind of, you know, cognizable way, so that they can move their case along and not be stuck there in the collections part forever, or any part of it. But yeah, we definitely do have them and send them down here, or give them the library's email. I communicate with them directly on the email, so they can, I always tell them, you can talk normal and I'll talk normal back to you, and we can kind of try to get you sorted. So, but they're lucky, because I've been to that zoo a lot of times with the pretrial and the garnishments and all that. So that's one area where I can help them a little more than others, you know.
Okay.
So absolutely, send them down.
So they've gotten the party has gotten their judgment. They've talked to Ms. Keller. They've gotten the forms filled out, but they can't just go ahead and serve any sort of a writ. They basically have to come back and file a motion and get permission from the court, correct?
Right. So they need a motion for a continuing writ, and continue, and then the actual writ has to be executed by the clerk of court. So once I sign that order saying yes for the continuing writ of garnishment, and then the clerk will issue that writ of garnishment, and then they'll have to go get it served.
And it's incumbent upon whoever the writ is in the benefit of to go out and have it served through BSO or the private process server.
Right.
Almost done, guys, almost done. And the flip side of all that is, after the plaintiff has gotten the writ for this, that, or the other thing, the defendant can have defenses that they could raise, and they would bring them back to you, basically saying, I'm a head of household, or, you know, the only money that's in this account is from my Social Security, and there are exemptions that would free that money up, but it doesn't happen automatically. Somebody has to file something to bring it back before the court.
So when that writ of garnishment is served, that information is in there. And also there is a time within which they have to do it. And so they can file a claim of exemption. That claim of exemption, again, once they do it, send it to the clerk's office, the clerk is going to right away bring it up to the judge, or bring it to the attention of the judge. And then we have to, as soon as possible, set that for a hearing. So then there will be a claim of exemption hearing. And so that form, that claim of exemption form, is just pretty much like a checkbox that says, I'm not looking at it right now, but a head of household or whatever it is. And sometimes they just check the box. Now, just because you check the box, that's not enough, right? So if you check the box, then the judge is going to set a hearing, and that hearing is to determine truly if you are the head of household. So I think when we set the order, I'm almost sure that when we set that hearing for the claim of exemption, it tells you that if you have bank statements, if you have tax returns, whatever you have that's going to prove, usually the tax returns are good, because it shows on the tax return if you're the head of household or how much income is there. Then there's going to be the judge is I'm going to ask you questions about not only about the money that you make, but how much you spend per month on everything. And then there is going to be an evaluation of the amount that's coming in and the amount that is going out. And for almost all of us, you know, usually what's going out is always way, way too much than what we bring in anyway. But you have to come with the evidence. You can't just say, I can't afford it. You can't just say, you know, I don't make enough money. You have to show proof, because that's what the judge is going to use to make that determination, to say whether or not you're exempt at this time from your wages being garnished.
In terms of the presentation, for all of you, I want to thank you very, very much. And I think we've had a great clinic here.